The other scary thing is that in Texas, an individual can now be sued for harassment if they're just an employee of the company, like in the HR department or the legal department. They can be now named as a defendant in a sexual harassment case, and that did not used to be the case. When this law was passed, everybody was shocked because no one had heard anything about the amendment, and it just came out, like I said, in September of 2021. So that was a much longer answer than you expected, but I wanted to make sure to get that right.
I'm going to get it right. I do think that you brought up an interesting, just through this whole conversation, you brought up an interesting point. It seems like the law changes a lot, and so not even someone could have a template or be running in this particular, think they had everything in order, and it's just outdated. I remember there was an example where I was like, hey, can you just look at this independent contractor agreement that I've got that you actually gave me like 8 or 9 years ago or something? And it's like, oh, this paragraph is no longer applicable and this one's changed. And so that happens all the time, just being able to make sure your agreements are up to date.
It really does.
This is the Bender CFO Podcast, where we empower business owners to gain financial clarity and maximize growth.
As we continue this advisor series, I brought on an employment attorney, and he provides so many great insights in this interview. We talked about agreements, setting them up correctly at the front end, all kinds of employment agreements, complaint agreements, making sure you have good bonus plans or employment handbooks, just all kinds of different things that you can do on the front end that really provide better communication with your employees, help you grow, mitigate risk. We talked about what happens when you don't do that all set up right. So sometimes you can set everything up correctly, and you do have to have an attorney or have somebody on your side to help you mitigate the costs, to decrease the costs of potential employment lawsuits and arbitration, all those things. So we talked about that. So I really think that there were so many valuable points brought up in this interview. So I hope you enjoy as we are talking with Sean Urich about key employment attorney tactics and just wisdom that's provided in this interview. I hope you'd enjoy this. Hello, everyone. Today, I'm excited to talk with an exceptional legal expert who is truly influencing the business landscape, Sean Urich. Sean is a highly experienced employment law and trial attorney serving as a shareholder at the Dallas office of the international law firm Ogletree Deakins. With a legal career spanning over 2 decades, he provides strategic counsel and litigation defense for businesses on a broad range of employment law matters. He assists employers with any matters related to employee-employer relationships, such as non-compete agreements, trade secret disputes. In addition to his employment law practice, Sean has significant commercial litigation experience representing businesses in complex disputes. He's a seasoned litigator with extensive experience in courtroom trials, arbitration proceedings, and defending claims before state and federal agencies. He's also a proud Baylor University alumnus. He earned his JD from Baylor Law School in 2001 after earning an undergraduate there. Sean is dedicated to providing top-tier legal representation to employers in various industries throughout Texas and the U.S. Please give me a warm welcome for Sean Urich.
Thank you, Shane. That was too nice of an introduction. I'm not sure I would approve of the over 2 decades of experience. That makes me sound like I'm getting up there in years, which I guess we all are. But thank you.
That's right. We both, I would just have to tell the audience, we both went to Baylor. We met at Baylor. So it's crazy when we think about the fact that it's been back in the 90s. Like, we're pushing 30 years or so. Is that right? Is it 30 years?
It is.
Yeah,
it
I'm
is.
Doing the math right. 30 years probably
30,
since we met.
30,
I bet.
Crazy.
But anyway, I brought Sean on here because I have I've worked with him in the past with my clients as a fractional CFO. There are just areas that, such as HR related discussion points, where it's important to have someone like Sean to go looking over agreements related to your employees. I had a situation recently where we needed a potential phantom stock agreement or some kind of equity agreement. I've had situations where there was employee issues where they stolen funds or embezzlement. That unfortunately is more litigation scenarios. There's whether you want to have a decrease your risk of potential litigation or after the fact if that needs to happen. So Sean covers a lot, or his firm, it covers a lot of different areas. And so my first question to ask you, Sean, is what inspired you to pursue this particular role that you're in?
Yeah, I'd probably have to go back to the Matlock TV series. Funny enough, I'm only halfway joking about that. I feel like back in the day when you're a kid watching some random TV shows with your parents, I feel like my dad and I used to watch that show all the time. And it got me at least intrigued that I wanted to be an attorney. And maybe I think all those shows tend to be criminal proceedings. So they're virtually in trial all the time, and similar to Perry Mason type show as well. And yeah, I think that sort of got my interest level peaked on going to law school someday.
Yeah, just knowing Sean for quite a while, it's like I can tell why he's in this field. Is great at arguing key points, and so I get that. So tell me a little bit more about how you work with clients and you really add the most value to them.
Yeah, hopefully it's on the front end, like you alluded to, and I'm able to help clients avoid problems. And that's really more rewarding sometimes to help clients get things in order and make sure they have all the appropriate policies and agreements and can avoid big disputes or issues down the road. My more proactive clients, I work with them regularly on their employee policies and agreements, handbooks, training, anything and everything that relates to the employer-employee relationship. But unfortunately, a lot of my clients came to me because they weren't necessarily having things done correctly. And so it may be that they were paying employees improperly or miscalculating overtime, or maybe they didn't have the appropriate training for their managers and the manager screwed something up, or they're now in a lawsuit or an EEOC or Texas Workforce Commission charge of discrimination, and they need us to help defend them. We do all that as far as defending against EEOC charges or any sort of complaint that's filed with an agency. And then if there is litigation, we defend those lawsuits, including trying those cases in court.
Yeah. So tell me, do you have an example of where, if somebody would have just simply had a little bit better initial agreement set up or the paperwork set up, they could have avoided a lot of the trials later on?
Oh, yeah, a lot of examples. So one, just a real easy one to understand or appreciate. There's an affirmative defense in litigation, which is that if you have a formal complaint procedure, then an employee later files a lawsuit and says, I was just harassed. In most cases, or many cases, that's going to be a sexual harassment case. Can be other types of harassment on other protected classifications like age or race or something. But if there is a complaint procedure in place, the person fails to make an internal complaint during their employment, but then later on says after they're terminated, let's say they didn't perform well, the company terminated their employment, and then they go and file a lawsuit claiming they were sexually harassed during their employment, and there was no complaint ever filed, but there was a complaint procedure, then that lawsuit under this affirmative defense that's out there, a court would be required to dismiss the case. But if the company didn't have an adequate complaint procedure in place, then the court does not get to dismiss the case based on the failure of the internal complaint. You have to actually have a written policy in place on who to complain to and all of that. Now, keep in mind, this only applies to companies, at least in the state of Texas, that have 15 or more employees. But if you have 15 or more employees, and in California and some states, you only have to have one employee. But here in Texas, if you've got 15 or more, then in that situation, you need to have that internal complaint procedure in place. And so, yeah, that's an example there of a situation where not having that complaint procedure can be really important.
Yeah, it's just like a template type procedure with certain names and like on this document, it sounds relatively probably not
It's
too complex
it's
of a
not too
document.
complex.
Yeah.
And so I'm embarrassed to say I have to correct one thing that I said, and I was realizing it as I was saying it. This is something that's ingrained in my head from doing this now for I got licensed in 2001, so I've
Yeah.
been 24 years. So a couple years back or so, I think it was maybe in 2024, let's see, we're going on the fly here. I'm going to give you some specific information on this because I think it's really interesting. And it was a huge development, actually. Beginning on September 1st, 2021, so time flies. I haven't had this come up yet, and that's why it wasn't top of mind. The sexual harassment law in Texas was amended in September of 2021. It's the only type of discrimination or harassment in Texas that does not have to be 15 employees now.
Okay.
So
Now it's down to
it's
one
down
employee.
to one or more.
Okay.
Not only was that shocking, but the other thing that was shocking is that the court changed it to where I think let me just confirm this. Yeah. You used to have 180 days to file a charge. They also extended that to 300 days. And other types of discrimination are still 180 days, but that one was extended to 300 days. And so anyway, to go back to what I said then, even if you've just got one employee, you really need to have that complaint procedure in place. And I still have yet to see a client with less than 15 employees get sued for sexual harassment. And part of that is that the plaintiff's lawyers they have higher damage possibilities against bigger companies. So those are not like the most attractive for the plaintiff's lawyers to make, but it's now a possibility. The other scary thing is that in Texas, an individual can now be sued for harassment if they're just an employee of the company, like in the HR department or the legal department. They can be now named as a defendant in a sexual harassment case. And that did not used to be the case. When this law was passed, everybody was shocked because no one had heard anything about the amendment. And it just came out, like I said, in September of 2021. So that was a much longer answer than you expected, but I wanted to make sure to get that correct.
I'm going to get it right. I do think that you brought up just through this whole conversation, you brought up an interesting point. It seems like the law changes a lot. And so not even someone could have a template or be running in this particular, you think they have everything in order and it's just outdated. I think I remember there was an example where I was like, hey, can you just look at this independent contractor agreement that I've got that you actually gave me like 8 or 9 years ago or something? And it's like, oh, this paragraph is no longer applicable and this one's changed. And so that happens all the time, just being able to make sure your agreements are up to date.
It really does. There's been a ton of changes in the last 5 to 10 years, more so than there was in the prior 10 years for sure. And if anybody has operations in states like California, Colorado, Oregon, Illinois, those are just to name a few, employees in those states, those laws are just constantly changing. And California is like another country virtually on employment law. You need to be hyper vigilant in those states. Texas, at least, tend to have a little less change. But yeah.
Yeah. Texas is one of those states where it's like the legislature only meets every 2 years for a few months. So at least they don't change as much from that standpoint. But it's changing all the time. Speaking of changes, I feel like believe it or not, it's been 5 years since the whole COVID thing. So all the COVID stuff, that was a ton of work, just things that are happening in that time period. But are there like more current trends that you're seeing that business owners really need to pay attention to?
I think as far as trends, I would just say that employees tend to be more educated. They have a much higher, I feel like the litigious nature of employees is even higher now than ever. Employees are more educated in part because of the internet and how you can just go on to Google and type in my rights for workplace discrimination or whatever an employee might type in. And then another kind of disturbing trend, I would say it's not disturbing that employees know their rights. What I would say is it's a little disturbing how much material can be found online that somebody could just dupe and turn into a complaint that may not even be valid. And
Hmm.
AI is part of the problem too. Recently, a client received this, very polished 3-page internal complaint, and the
Hmm.
employee in their emails would tend to be riddled with typos and not able to draft something so well written. But then they turn in this just immaculate internal complaint. And so I think we're fairly certain that this was some AI generated complaint. So now employers have to worry about that as well.
I tell you what, I have personally been utilizing ChatGPT more and more, and I did notice every once in a while I've been training it, so I'm trying to make it sound like me. But at the end of the day, it's like maybe we need to put a couple errors in there to make it look like it's from a real person, not too AI generated. So that's funny. That's funny. So we talked a little bit about mistakes that businesses are making. I don't know, are there any other key areas of mistakes that you don't want to make sure we touch on that business owners make?
Well, I think that in general, the medical leave scenarios that are happening with I mean, if you're of an employer of any size, you're going to have an employee at some point who has a difficult personal medical situation, who wants to take leave either intermittently or on a permanent basis. And we regularly see employers mess that up really badly. One just simple example would be the job position should be held open longer and the employer decides to fill the position in a very short period of time. Maybe they tell
Mm,
the employee bad information, such as, let's say they're an employer that has FMLA. So typically that's only going to be companies that have 50 employees within a 75-mile radius of that job location. And they grant the FMLA. And we still see employers sending out letters saying, upon the expiration of your FMLA, you will be required to return to work. That's not
mm,
necessarily true. If the employee needs additional time under the Americans with Disabilities Act, the employer may need to provide some additional leave under the ADA.
mm,
And then another example would be companies still have these outdated policies that say you can only be out of work for a maximum of 180 days. And then at that point, your employment will automatically terminate. Those are
mm.
outdated policies that used to relate to, I believe there was some origination with the workers' comp system or something. But anyway, those types of automatic dismissal policies based on how long you're out on leave are unlawful. And so those need to be removed from company handbooks.
Yeah, yeah, that's great. There's just so many like specific things that I think is hard for, especially small business owners, especially the ones that I work with. Some of them do have, especially the larger ones, can start having HR departments, but sometimes, or maybe they're using fractional HR. Many of them
Mm-hmm.
don't always have that. Even just trying to figure, you just can't know all these things. It's too many things. And what do you feel like in your experience makes working with other financial professionals, other fractional CFOs really successful?
To find a good one, obviously, is good. And I know that you've done great things for your clients, but I think it's just good, clearly good business to have your records in order, your financial records in order. And I see that whenever a client has a potential situation with respect to, let's say, an employee embezzling money, we're having to try to prove what happened there and retrace the steps of what happened. Sometimes companies have great systems in place and understand how the books are kept and all of that. So it helps in a variety of ways.
Yeah, like I had alluded to before, it's amazing how many things out there that you can make that either cost you more money because you didn't do them. Let me give them some examples. And of course, then if you run into a situation, it doesn't mean you could probably do everything right, fairly right, and still run into some situations with employees, or you just need an attorney to help you with. Unfortunately, that's just the way it is. And Sean mentioned we're kind of in a litigious society. It doesn't really matter. And then at that point in time, do you just roll over and settle or not? And what do you do? And it can be worth a lot of money. And so having somebody, an advisor, an attorney like Sean to help you with that is hugely important. So I think that we make sure we touch on all of the different things that you could potentially help. What other transactions or types of things that you do that you really just, if you were to have a checklist and like, hey, we know you really want to do all these things. What are some good things that they want to bring you in to help?
Yeah. So thanks for asking that. I mean, I think one of the top things would be, I've referenced it, but having a really good employee handbook, having good employment agreements for your upper level employees. I see sometimes a company won't have an employment agreement with their C-level employees. Another example would be a lot of times our clients will have commission and bonus plans that are either not in writing or are written so poorly that you would read them. And sometimes I think our client doesn't understand that maybe they're reading it and they have an understanding of the industry, and it's in their mind it makes sense, right? Because they're using high level big picture terms or describing it in a way that they think makes sense. And then I'll look at it and I'll be the attorney layperson, so to speak, looking at it because I don't necessarily know all the jargon. And I read it and I'm like, what about this? What about that? And the next thing I'm pointing out a lot of ambiguity in the policy. And the reason you need to think that way is because if there was a dispute with an employee over how much commission is owed or whether the commission must be paid out on termination, that's a big one, right? If you have an employee who is terminated or quits before the commission is calculated, but they've done everything to arguably earn the commission, what does the written policy say about how commissions are treated on termination? A lot of times the policy doesn't say. So then we've got to look at what's the past practice, what's been happening over the last several years. And you don't really want to have to rely on past practice. You want that written policy to very clearly say when and what time the commissions are due or earned, how are they earned? In other words, somebody quits a week before the commission is going to be paid, are they entitled to receive it still? Or did they have to be employed on the date it was going to be paid? Those are the types of things that I will help clients revise and get in good shape. And then as far as other things, I do a lot of non-compete and trade secrets work. So anybody that might need a non-disclosure, non-solicitation of employees and clients or non-compete agreement, I draft those. I help analyze those. If a client is going to hire a new person and they have a non-compete with the former employer or the one that they're working for still, I would look at that and advise my client on the risks of bringing that person on.
Yeah, that's great. I tell you what, I know I've had you help with some of those agreements, and then I was just thinking through because I get bonus and commission agreements are a common request that I get. Mainly just we're putting together the financial, and we have a plan for this year, and we want to hit revenue targets, and we want to hit certain EBITDA targets. We want to hit certain metrics to be able for the business to be profitable. And they want to align the bonus structure accordingly, which makes perfect sense, right? You want everyone to be motivated with the same purpose. Just making sure that you have all these caveats and think of everything is a really essential thing to do. So that's a good suggestion. I may have to have you run through some of them that I'm having in mind right now. But it makes perfect sense why you'd want all of these things to be reviewed by somebody that may just not even be obviously just having it not either within the company culture, so therefore the jargon is right, or thinking of every scenario because it's hard to think of every scenario. So what happens if this person leaves, or what happens if they're terminated due to poor performance versus it's just a layoff, let's say, or whatever. Are there different scenarios that happen in that situation? Yeah.
Similarly, PTO payout is a big one we see, and companies have a lot of different policies on or vacation will be paid out on termination. Some companies have it written down where the PTO gets paid out if somebody is terminated for any reason other than for cause. And it might say if you're terminated for cause or for an involuntary reason that the company decides you haven't met the job expectations, and you don't get PTO or vacation. But if you're laid off in a reduction in force or you just resign, then maybe you get it. I'm not sure I love that just because it can lead to a dispute, but some companies do it that way. Other companies will say you never get PTO or vacation paid out. Texas is the state that doesn't require it. I believe California, I think it's required to pay it out. So that also depends on which state you're talking about.
Yeah, that's great. I definitely appreciate this advice. As we wrap up this discussion here, I just like to ask, what motivates you in your daily work?
I alluded to it earlier, but just helping clients to get things right and just trying to provide as much value as I can to help people. A lot of these people are my friends that I work with or become friends over time. And you want to do whatever you can to help them be in compliance, help their company be successful. The worst thing is when a client calls me with a bad mistake that they've made on something that they could have avoided had we just talked about it. So yeah, I think that's probably it, is just being a valuable resource and having also clients who are my friends.
Yeah, that's great. And so I'm looking back behind you, just since we're gonna wrap this up. We've got pictures of your family there. We got, looks like the Baylor National Championship. Is that what that is? Is that the basketball championship?
It is, and to be more specific, Shane, that is a piece of the court. And
Oh,
so,
wow. A piece of the court.
there was literally a game played on that little framed piece of wood back there. But that's
awesome.
the national title game from 2021 in Indianapolis. Yeah. And when the games end, this company that makes those things every year, they buy a large section of the court. I don't know how much, they get all of it. And then they make all these different pieces of framed items. And I even have a paperweight with part of the court on it. So I had to capitalize on that while we could. You never know, you're going to get another national title.
Yeah. We'll be back there again one day, right?
Someday.
So maybe not this year, but someday. But yeah, no, this is a good discussion for sure. And like I said, the value, there's so much value that's even provided in this discussion that I think business owners will really be able to take to heart and try to figure out ways to minimize risk and effectively save money. But I think the underlying part here is that you just want to be able to communicate the best way you can to your employees. And having good agreements is just a great way to communicate and motivate them. If everyone knows where they stand, whether it's compensation structures, equity type agreements, employee handbooks, whatever it may be, you're just making sure everybody knows where they stand and there's not confusion. And because confusion usually creates a lot of sideways energy. So all that is providing better communication and better processes so that you can grow your company and be successful. So I think that's what we all want as business owners and as those who advise the business owners. So thanks a lot, Sean, for this time. I appreciate it. And you have a great week.
Yeah, you too. And thanks for the invite. I really appreciated it and enjoyed the conversation.
Yeah, great. Thanks so much for listening to the Bender CFO Podcast. Help us out by subscribing on YouTube so you don't miss another episode, or listen to us on Spotify and rate us 5 stars so more people can get this content to help their businesses grow and be successful.